All right, welcome everybody. It's about 12:02. We'll go ahead and get started. We might have a few stragglers come on, but that's okay. Just a note to everyone, we do record these meetings, so if you need to step out for whatever reason or you lose connectivity, this will be posted on our website. Usually it's up live about midweek the following week. Also, if you need a replay of it, you're welcome to find it there. Our webpage also has prior Lunch with Liz's, so if you have a yearning desire to know about some different topic, you can find a lot of topics from our previous monthly lunches there as well. Well, if you don't know by now, I'm Liz. I'm your hostess this afternoon for Lunch with Liz. Thanks, y'all, for taking the time to join me. I started Lunch with Liz years ago because I found a need to be able to just have discussions with people about estate planning issues, so that I could hopefully kind of kill some of the myths that are out there about estate planning. And it's hard to do that if you're just writing a blog or a podcast, because those can be misinterpreted. And this is a way to just have a conversation so that you don't leave here not knowing what you want to know. The way today will work is I do have some slides. I know they're kind of boring slides in general, but I do think they help kind of convey the information we need to do today. There's a myriad of ways for you to ask questions if you have them. You can put them in the chat. There's a chat bar. Usually it's on the lower bar part of your screen. You can throw your question in there. During my presentation, if you don't understand something, you want clarification, go ahead and come off mute and let me know, and we'll talk about it right then. And then also at the end, I'll open it up for questions that way. And then if you're just super, super shy, I always hang out a little bit afterwards, after people are leaving, if you have a question you just didn't want to ask in front of everybody else. So today we're breaking up the presentation into three parts, really. One is just general parts about, like, just the basics about what a trust are. If you have deeper questions about what trusts are, I did a whole Lunch with Liz on that a couple of months ago, and Vicki will share that in the chat at some point during this presentation so that you can go watch that if you want. The second part will be about blended families. The third part will be about special needs trusts. Please, please, please know that this is an extremely general overview. You are not going to walk away from this with your how-to kit about how to take care of your family if you're a blended family, or how to take care of your special needs child with a special needs trust. You're just not going to. The nuances for everybody's situation is so complex that the only thing you're really going to take away from this is if these are scenarios that fit you and you want an estate plan that addresses them, you really need to go see someone who is experienced in whichever issue that you have. And you may have both. So you really want someone that's dialed in and understands the nuances of it all. So with that, we will click on to the next slide. There we go. So remember I said we're going to break it into three parts. And the first part is, well, just what the heck is a trust anyway? And if you've been in my Lunch with Liz's or you're a client of mine, you know that I always use the analogy of a trust is like a bucket. It is a place for you to put all your assets. So think about it this way. Let's say that I own a house, I own a checking savings account, and I own investment account. So if I don't have a trust, those are just titled in Liz Moneymaker's name. But if I create my bucket, my trust bucket, then I change the name, I retitle all of those into my trust. So now they are owned by Liz Moneymaker's trust, not me. That's why trusts become helpful, because trusts don't die. I will eventually die, as much as I don't like to think about that. But if I have my assets in a trust, my trust lives on. That's one of the key components about why a trust is beneficial, is because it can avoid that terrible word probate. And if you don't know what probate is, it's just the legal court case that we use if someone dies without some other way to transfer their property. So probate is the way a judge gets involved make sure the person's debts are paid, make sure that their assets get to who they want to go to. A trust, on the other hand, remember, think about it like that bucket, doesn't have to go through that probate process. Your person that you put in charge of the bucket after you die, they follow your instructions and they distribute the assets as you see fit. It's really a way for you, and this is the phrase I use, a way to control from the grave. And for our purposes today, when we're talking about the blended families and the special needs families, that's really what you're trying to do, is control from the grave. You're trying to control where the assets go if your spouse inherits them before your children do. Or on the special needs spectrum, you're trying to ensure that the assets that you're providing for your children don't kick them off of public benefits. So it's a way of, even if you're gone to the great beyond, you can control what happens to your assets. But keep in mind, too, if you don't fall into those categories and you just accidentally stumbled into Lunch with Liz, there are other reasons a revocable trust is helpful. It could be helpful if you have minor children, could be helpful if you have a beneficiary, and I have clients that this happens to all the time, that their children have alcohol issues, drug issues, money issues, gambling issues, and we want to control if, how, when they get that money. So a trust can come in handy even if you don't have a blended family or a special needs trust. I don't want to get into the weeds too much about all the scenarios involving a revocable trust because, like I said, we do a specific Lunch with Liz about that. But the key thing about any trust is, think about that bucket analogy I gave you. The only way a trust works is if you get everything in the bucket. I have a case right now, a probate case, where the client, or not my client, but the deceased had a trust that she drew up in Illinois with a lawyer. She moved to Florida, and there were things that she owned in Florida that weren't in the trust. So now she really has the worst of all the world. She passed away. So now we have assets in the trust, so we have to do a trust administration. We have assets that were not in the trust, so now we have to do a probate. So we're actually doubling the work because she didn't make sure everything was in her bucket. So if you do work with a lawyer and you get a trust, funding the trust, putting your stuff in the bucket is the key thing you want to remember to do. Let me just check the chat. I see there's a couple things in the chat. Okay, nothing I need to deal with just this minute. All right, we're going to move on then to my next slide. So there are three components of a revocable trust. There's the person that creates it, so that's you. We call them the grantor. You might also see trustor in there, or settlor. That's the person that's drawing up the trust, the person whose assets we're going to put into that bucket. The second person is the trustee. That's the manager of the trust, the person that is in charge. While you're alive, typically it's you. Sometimes, though, I have clients that make their children trustee right away due to health issues or something like that. But generally, you're the trustee, and then you name someone or some entity to take over when you become incapacitated or you pass away. And then the third person is the beneficiary, the person who benefits from the assets in the trust. So think about it. While I'm alive, let's say I create a bucket. I put my house in there. I put my checking savings, my investments in there. I'm the beneficiary while I'm alive. So I'm that person that benefits from my trust. When I die, that beneficiary becomes whoever I've named, my children, a charity, other friends, other loved ones, that sort of thing. So those are the three players, and no matter what kind of trust you do, that are going to be involved. All right. Why would, in the context of blended families and special needs families, would we choose a trust over the will? Really, it comes down to that one phrase I used a couple slides ago, and that is your ability to control from the grave. You can control from the grave via a will, but it has to go through the probate process then to create the trust that would ultimately then help you control from the grave. That is a way to do it, but the gold standard, if you are needing to put these kinds of parameters in place, is to do it ahead of time with a living trust versus having your will say that a trust is created after you die. If you do it that way, you set up a trust, or you say a trust should be set up after you die, you're putting all the work and all the decisions off on somebody else. Versus if you create it while you're alive, you get to do that thing we talked about, which is controlling from the grave and deciding who and what ultimately gets the assets. Unlike a will, a trust is private. It's not a matter of public record. And it lets you name trustees in the event that you become incapacitated. So a will is only in effect when you die. But a trust is in effect while you're alive and can stay in effect even when you become incapacitated. So that's why it can be handier than a will. Don't leave here, though, thinking that Attorney Liz Moneymaker says we should have a trust and not a will. That is never my go-to answer. My philosophy is, what is the simplest way we can accomplish your goals? Sometimes it's not with a trust. Sometimes it's with a will and beneficiary-based designations, pay on death, transfer on death designations. And some financial planners, and I know we have a couple of them on the call today, I'll get their clients into my office and they say, well, our financial planner said we need a trust. And sometimes they do and sometimes they don't, but I just walk them through what their options are and how they can sometimes achieve their goals without needing to get into the complexity of a trust. All that being said, if your goal is controlling regarding a blended family or a special needs child, you are more likely than not going to opt for the trust-based route because it's going to give you the most decision-making power and the most flexibility to care for your ultimate beneficiaries. All right. Next one. We're going to move on. We've talked about the trust in general, and now the second part, we're going to talk about blended families. And when we talk about blended families, we're generally talking about, Joe was married before, and he had, 3 kids from that relationship. They got divorced. He marries Marcia. Marcia had, 3 kids from that other relationship, and now they have a blended family. And I can't believe that I just left the opportunity to use a Brady Bunch analogy right away. But if you think about Brady Bunch, they're the ultimate blended family, right? So typically what happens when clients come to my office with this concern is, Carol is concerned that if she dies before Mike does, Mike's going to leave all of her money to his boys, and her girls are going to be out of luck. So she wants to put a plan in place to ensure that if she dies first, that, Mike can use some money, but ultimately her money is going to go to her children. Or they might decide together that whoever dies first, they can use some money, but ultimately it goes to the 6 kids. There's no right or wrong way to do it. But essentially what we're doing is, again, trying to control from the grave for the spouse who dies first. Some of my clients have called this the bimbo clause. A little crass, I know, but it is, what if it's a family that's not blended, that it's mom, dad, 3 kids. Sometimes they come and say, I want to control from the grave because if I die first and he remarries, I don't want all of our assets going to the new spouse. So these are different ways that we can control for that. How do we do this? Originally, the title of this slide was How a Trust Solves the Conflict. But as I thought about it, the trust was never going to solve the conflict. The trust is going to lessen the conflict, or at least that's what we hope it will do. And there's a couple different trusts that we use a lot to do this. These are just examples. There's a dozen other ways a dozen other types of trusts just off the top of my head that I can think of that we could use. And you decide this with your attorney based on what's your estate size, what types of assets do you have, what type of family structure do you have, what's your risk tolerance, what's your protection goals. For example, do we have worries about creditors? Do we have worry about lawsuits or bankruptcies? Do we have worries about future divorces? All of these things your attorney is going to take into account when he or she gives you their recommendation about which scenario to use to protect the family. But a couple examples up on your screen. A subtrust, think about this. Think about your bucket, right? You have the bucket. You and your spouse create this bucket. Life is hunky-dory, and then you pass away. So a subtrust would take some of the assets to your surviving spouse and then take some of the other assets to protect for the children. The Q-tip trust, and Q-tip, if you want to know, stands for Qualified Terminal Interest Property. Much easier just to say Q-tip. This provides that once you die, the bucket then allows the surviving spouse to get the income from the trust, but the actual assets in the trust are preserved for the children. Sometimes when we sit down with clients and we talk about all these options, their desire to control from the grave kind of goes out the window, because they realize that once they die with these types of trusts, the trusts become irrevocable. So the surviving spouse, we don't have a crystal ball about what might happen to the surviving spouse, but this kind of locks the surviving spouse in to what assets and what income they may be entitled to with the trust. There could be limited access to principal depending on which option you choose, so that, if the surviving spouse needs money for something legitimate and not a bimbo, they can't get to it, or it's very difficult for them to get to it. There can be a lot of administrative complexity with these types of trusts after someone passes. We've got the survivor trust, we've got the kids trust, and both of these things have to be managed by somebody. And then, I told you I changed the title of the slide because it's structuring to lessen conflict, but you can still have conflict. Imagine, the whole Carol and Mike scenario. Mike passes, and now Carol's still in the house, and the boys don't like the way Carol's redecorating the house, or the boys don't like how Carol is taking care of the house, because that ultimately is their asset. She just gets to use it during her lifetime. So there still can be conflicts about real property or with investments that an ultimate beneficiary may be unhappy how the surviving spouse is treating those assets. So it certainly doesn't mean that it's kumbaya for everyone. It just gives us a way to preserve assets is really all it does, or preserve income. All right. I probably should have retitled this slide too, Maintaining Family Harmony. It should be like praying to maintain family harmony, but doing trust this way do help us have a legally binding roadmap, so we can lessen friction. We can't get rid of friction altogether, most likely, but we can certainly lessen it. One way to do that, and I think I have a checklist. Vicki, if you'll throw the trustee checklist in the chat. Some people choose to name a child or a friend or a sister-in-law as the successor trustee. But when you have these blended family situations, oftentimes it's much better to have a neutral third-party trustee, whether it's a bank, a trust corporation, a professional fiduciary. A lot of people don't realize there are people out there whose job it is to be a professional fiduciary. It's their job to be a trustee. It's their job to be an executor under a will. And if you anticipate that you could have some conflict, or it's a significant enough money that there's going to be conflict, you definitely want to consider one of these neutral third-party trustees. And it's a little short checklist regarding trustees, just kind of help you walk through when having a family member is a good idea, and when maybe hiring a professional fiduciary is a good idea. So that I think, yeah, I'm gonna move over to special needs trusts. But before I do, I want to open it up to anyone who has questions on the blended family. You're not relegated to ask them now if you want to wait till the end. But let me look in the chat to see if there's any questions. All right, question. So anything with a title or that leaves a paper trail needs to be in a trust. It depends. That's something you're going to walk through with your lawyer about how to fund the trust. It depends on, for example, retirement accounts we don't put in the trust. Those have a beneficiary and certain tax advantages that we would want to make sure that those stay separate. There are times that I would make the trust the beneficiary of a retirement account, but sometimes that doesn't make sense either. So remember when I said at the very beginning, like, you're not going to go away today with a checklist of everything you need to do, because it all is going to depend on your specific situation. Whether there should be a separate gun trust is outside of my wheelhouse. I don't do gun trusts, but I do know that depending on what kind of weapon you have to do a gun trust in order to be able to transfer those when you pass. Some things like my 380, I don't need a gun trust for a pistol. But if you have some of those federally, licensed guns, you would need a gun trust. But if you don't know one way or the other, I have 2 experts in gun trusts. I'm happy to get you their names if that's something you want to talk. So, and if that didn't answer your question totally, let me know, Greg. All right, next question. Celeste, is a trust established instead of a will, or is a trust part of directions set forth in a will? Good question. So when you have a trust, and I never know how to articulate this cleanly, but when you have a trust, you're going to have a will. Think of the trust like the bucket, remember? What the will says, it says, hey, you know what? Anything I didn't have in the bucket, either accidentally or whatever, I want the bucket to control. So I gave you that example of that Illinois woman who had that Illinois trust. So she had that will. It's called a pour-over will. And it said, anything that I didn't have in the trust, I want it to be in there. That's why now we have to probate things, put it in the trust, and then administrate it out of the trust. The will is also important if you have minor children, because that's where you name your guardian. It's important because that's where you name your personal representative. You might be familiar with the term executor. In Florida, we use personal representative. That's the person that's going to be able to sue on your behalf if you die due to someone's negligence, for example. That's the person that's going to be able to deal with the IRS. That's the person that's going to be able to deal with other government agencies. So the will is still important, but the trust is what's going to control all of the assets that were named, that were titled in the trust name. Throwing another wrench into it is you may have assets that are outside of both purviews. That retirement account, for example, that could have, your son's name as beneficiary. So it doesn't matter what the will says, it doesn't matter what the trust says, it matters what that beneficiary form says. And sometimes we have a combination of ways that things pass when somebody dies. Ultimately, you want the combination to be tight enough where we don't have to worry about the probate process. And that's why when I talked about earlier, my goal is whatever the simplest plan is for you to get where you're going is what I recommend generally, is because simple is something you can keep up with. When the more complex things that we do, the more you need to be on top of it year after year after year to make sure what happened to the Illinois lady doesn't happen to you. Next question. Is there any way to have all owned assets roll into a trust? Or does the trust need to be redrawn periodically during life as assets accrue? No, that's one of the lovely, lovely things about a living trust is you've used that bucket analogy, which you're going to be tired of it by the end of this program, I'm sure, is you can take things in and out of the bucket. So you sell one house, you take it out of the bucket. You buy a new house, you put it in the bucket. You get a new investment account, you put it in the bucket. Any way to do all of that. The only time you need to update your trust is if you're changing your trustees, so the people that are in charge of your bucket after you die, or you're changing who gets your stuff when you die. There may be some other reasons, like tax, there's new laws on the books, and if you're my client, you're going to get an email from me saying, hey, you need to come in and talk to me about your trust. But generally, for you coming to me, it's, am I changing the people in my trust, either who's in charge or who's getting what. Other than that, you can take stuff in and out of it all that you want. All right, that's all I see on the chat for that. Do not think that you've lost your opportunity, though. If you have another question, just generally before we're finished, let me know. All right, so now we're going to move on to special needs planning. When we talk about special needs planning, we're generally talking about a child, although that child could be 47 years old. There could be an adult child who has some sort of special needs to the extent that they're on public benefits. They're receiving SSI, they're receiving Medicaid. And if they received a chunk of change, it would kick them off of those programs. So special needs planning is a way of ensuring that in general terms, the assets that the parents have, attained through their life, that if something happens to those parents, we're going to create this special needs bucket so that the kid can remain on SSI, Medicaid, all their other public benefits, but still have this pot of money to use. Generally, in most states, a child can't have more than $2,000 in countable assets. There's some exceptions with ABLE accounts, some exceptions with depending on some other assets, but in general, that's what we're looking at. So if mom and dad die and they inherit, $20,000, that's going to kick them off of public benefits, and we're going to have to do some other planning to get them back on. So for parents with special needs, the best thing to do is proactive planning about how to ensure that the child is taken care of. I did have a frequently asked questions handout too. Vicki, I meant to ask you to do that earlier. If you could throw that in there, that has some special needs questions on there too. That might jog some other questions from you. All right, when I go to oh no, I didn't want to go forward yet. Okay, so I did want to go forward. Okay, so what a special needs trust does is it ensures that the person can use the funds from parents, grandparents, whoever is funding the trust for supplemental care. Things that are not covered by Medicaid. So think medical things, dental things, eyeglasses, vacations, therapies, housing, transportation, companions, private care, anything that Medicaid's not going to cover itself. What you can't do is use it to pay cash directly to the special needs person. And generally, you have to be careful about paying for food and shelter because that's what SSI is for. There are some situations where we do that anyway, but you'd want to work with your special needs attorney to know when those occasions would work and when they wouldn't. There are two kinds of special needs trusts, and you can also hear them called supplemental needs trusts. One is a first party. That's not what we're talking about here. But a first party would happen when, let's say, the son inherits the $100,000 from the parents and he's on SSI, and now he needs to do something with that $100,000. He can create his own special needs trust. So it's called first party because he's the beneficiary of that trust. The drawback, why we don't want that to happen, is there's a Medicaid payback from that kind of trust. So if I put that $100,000 and I ended up getting, Medicaid benefits, when I die, if there's any money left in that trust, it's going to go to pay back those benefits to Medicaid. A third-party supplemental needs trust, that's the one we're talking about here today, is when someone else creates it for the special needs person. It could be a parent, it could be a grandparent, it could be an aunt and uncle. It can be anyone that creates it for that third party. But the benefit of the third party is when the special needs person passes, if there's any funds left in that, there's no Medicaid payback. It would go ultimately to the other children or to charity or to wherever the creator of the special needs trust said it should go to. We had talked about wills versus trusts a slide or two ago as well. You can create these special needs trusts within a will. I know that sounds confusing, but let's say that I have a special needs child and I have a will that inside the will it says if I die and Clara is still alive, then I want a special needs trust to be created to get all of my assets. That is a way to do it, but it requires probate. It requires the trust to be set up during the probate process, and it requires all the work to be done by someone you probably don't like very much because you've put it all on them after you've passed away. It's still a way to do it, and I certainly go through that option with my clients, but typically the way they choose is they want the decisions to be made ahead of time, and they want to create this bucket now. And one of the benefits of doing the bucket ahead of time is if Grandpa is going to give the kid money, if Aunt Susan's going to give the kid money, that bucket is alive and well, so we can start pouring stuff into it even before the parent dies. That's why the third party can be beneficial when we have more than one person trying to give money to the special needs child. Beyond money, what the trust can do is help you have all the guidelines in place, well, as much as you can, for how to care for your special needs child. We can have a trust advisory committee, so that's people like teachers and loved ones and care companions who know the child and who you want to be in the decision-making process if you're no longer there. I always also recommend to my clients that we do a letter of intent, which is hey, if I'm not here, here's everything I know about my special needs child, what they hate, what they love, how to get them to get dressed, how to get them to communicate if they're hurt, whatever. You know, if you were gone tomorrow, what would someone need to know immediately to make sure that your child could live the best life that they could without you there who knows everything, right? And I have a sample of that letter of intent too, Vicki, if you'd put that in the chat. All right. Summary is just, hey, the trusts let you control from the grave. They help you keep money from potential future spouses of your spouse, or making sure that it ultimately goes to your own children if that's what your preferences are. And then doing a supplemental needs trust or a special needs trust ahead of time, what we call a standalone special needs trust, ensures that your child never gets kicked off of public benefits due to receiving more than that $2,000. Let me see if there's any questions on the special needs trust. I think we're going back a little bit here, but that's okay. Do you name every asset, for example, 401k investment account in the trust? What if some of those accounts are used up or closed after you pass? So generally, if it's a retirement account like an IRA or 401k, we don't put those in the trust. Those will have a beneficiary. The beneficiary might be the trust. The beneficiary might be a human being. Just depends on what the distribution plan is for that particular client. If some of the accounts are used up or they're closed, then we don't worry about it. Think about, the open bucket. Things are taken in and out, so that doesn't matter. If you have an account that's titled in the trust name but there's no money in it when you die, it's just a zero asset. That's all. What happens in a retirement account if the beneficiary has passed away as well? That depends on state law, but generally it goes to the intestacy rules of your state. So for Florida, if there's no beneficiary, then it goes to your spouse if you're married. If you're not married, to your children. If you don't have children, to parents. If no parents, to sisters, and on like that. Typically, if we have a beneficiary-based account like an IRA or 401k, I would say, hey, have it go to your spouse or whatever, and then make the trust the secondary beneficiary, because the secondary beneficiary is not going to die, because it's a bucket, and buckets don't die. But don't take that as legal advice, because it's going to depend on what your goals are and what the overall distribution plan is. Would a letter of intent help with kids who are struggling with mental health and addiction issues? I think it helps to the extent that someone who doesn't know your child, like you know your child, has that knowledge. If you have a child struggling with mental health or addiction issues, we'd want to incorporate some sort of support system language in the trust to ensure that whoever you're naming to take over for caring for your child knows what assets you've been using. And by assets, I don't mean money assets necessarily, but governmental assets, private assets to help with that child's particular issue. So I think that it would help, because knowledge is power, and no one knows your kid like you do. All right, so we're going to open it up for questions. I'm going to stop the show. So you can come off mute. You can throw a question in the chat. You can leave if you're done, if you've gotten all the information you wanted to. I won't keep you here unnecessarily. So if you have specific questions about probate avoidance, we are doing our Lunch with Liz in May is about probate avoidance. Next month is specifically focused on women. It's Women's History Month, so we're going to do women in estate planning. In April, it's just estate planning basics. We're going to hear some of the same stuff we talked about today, trusts versus wills versus beneficiary accounts, that kind of thing. And then May, like I said, it's things you can do to avoid probate that you don't even need me for, things that you can do on your own to help you avoid probate. And then we do have, I think it's already in the chat, we do have that what is a trust, Lunch with Liz that we've done. We'll do an update on that probably in the latter part of the year, but we don't have a plan to do that before August. If you have subjects that you would like to hear on Lunch with Liz, you can shoot an email, and Vicki will put her email in the chat if she hasn't already. If you want the slides, you can email her. She'll send you the slides. And then the program itself will be up on the website and on our socials next week. All right. Well, you're welcome. Thanks, everyone, for tuning in. Like I said, I'm going to stick around in case you're too shy to ask a question in front of people. If you want to talk to me further, Vicki is your point of contact. I'm happy to set up a complimentary consultation. We do those in our St. Pete office or via this platform, via Zoom. So, and like I said, you weren't going to get a how-to guide with this one. It just gives you some general knowledge to take to your lawyer, if you go with someone else, about this is what I want to talk about here. I know that I can control from the grave, but what happens after I die? What type of problems are my heirs going to have if I decide to go this route? Are there other ways that we could do this? Let me check the chat. Wow, you're welcome. Thank you.
Hi, Liz. Hey, this is Celeste Combs. Good morning. Sorry, I don't
Hey,
have my
Celeste.
video on. I haven't even had a shower today. I got to
you
get in the
you didn't
shower
have to
after
disclose
this.
that.
I was a little confused or clarification on
Yeah.
Social Security. So, if I have Social Security income, the impact of that on the individuals, none.
No, it's not Social Security like from what you paid in because you were working. It's Social Security. It's SSI. It's the program for poor people.
Oh, I
So they're
got it.
two different
Thank you.
things. Yeah, yeah, yeah.
Making
So we
sure I'm
don't
good.
we
I haven't
yeah.
filed for Social Security yet. I'm in a situation where I might be forced to do that, unfortunately. But so I just wanted to make sure I understood. I'm still kind of figuring it all out. I'll set up an appointment to chat with you some more.
Yeah, absolutely.
Thanks so
And
much.
one of the other things that people sometimes get confused on is there's Social Security disability, so SSDI, and then
Yeah,
there's SSI. So SSDI is you've been paying in, you've got your W-2s, you've paid the payroll tax, you've paid all that stuff, and then you get to where you can't work anymore, an injury or other medical condition, so you file for Social Security disability. An inheritance doesn't impact that because you're getting something that you're entitled to, because you've paid into the system. Whereas SSI is, again, that safety net program we have for people that make a very low amount of money or no amount of money. So if they get money, the government says you can't have that windfall. And that's when we have to do all the special needs planning.
got it. Yeah, I know I'm in a situation where I am looking at Social Security income. My mother is stage 4
Mm,
cancer sick. I'll
I'm
have
sorry.
some trust income. And I don't know like what will happen to my Social Security. That's where one of my questions is around it.
Okay. Well, happy to talk to you. All right. Anyone else? All right. Well, thanks everyone for coming. Like I said, I'm going to stick around, but if you don't have any questions, please have a great day. And even if you're not a woman, you want to come listen to estate planning for women next month, we'd be happy to have you. So have a great, yeah, Greg, come on back. Uh, have a great day, everybody. Thanks for joining.
Actually, that question that Greg has is very interesting
Oh,
right
I
there.
just did. Should
He
your
just
digital
posted it.
Yeah. Should your digital assets be in a trust, like passwords and accounts, or just leave in a sealed envelope with everything? So, digital assets, like you think about, all your cloud stuff. So, we do an assignment when we finish with a trust, and we assign your digital assets into the trust. But think about, let's say, your Bank of America account. Well, that has some digital asset parts to it. So if the trust is going to control that, that account needs to be in the trust. So that's something we walk you through as well, is where the digital assets are. But that still doesn't help your person that's in charge after you pass know how to access those. So having a way to have a main password holder, or a sticky note. There's a bunch of different ways to do it so that your successor trustee can have access. Last month on Lunch with Liz, we did a "Oh, I'm dead, now what" presentation where I talked a lot about this, about if you're incapacitated or you pass away, how does someone get into your Google account? How does someone get into your Facebook? How does someone get into your emails? And there are ways that you can name someone ahead of time who would have access to those accounts. But things like online banking, online investing, you would want to make sure that your successor trustee knew where those passwords were. Whether you were using like one of those uh, master password apps, or you were using the legal pad in your safe. So, oh, thanks, Vicki. Vicki put a link to that in case you're dead now, building your In Case I Die kit. Even if you don't want to listen to that, if you click on that, there's a checklist of things that you should do to get your affairs in order. And that's the case whether you're single and you don't necessarily have anyone living with you, or you're coupled up and one of you is the one that's paying the bills and knows where the accounts are and knows when the cable gets paid, what account the cell phone gets paid out of, making sure that even if that person doesn't want to know, when they have to know, there's a way for them to figure it all out. All right, great question there. All right. All right, we're gonna.
Thank you. Thank you.
Yeah, you're
Appreciate it.
welcome. You betcha. Thank you, Greg. Thanks, everybody. If you think you might want to talk, let me know. Otherwise, I'm going to sign off. All right. Thanks, everybody. We'll see you next month.